Hi there. My name is Sasha Westerman Kuning, and I'm a board-certified immigration attorney based out of Fort Lauderdale, Florida. I'm here to talk to you today about a reinterpretation of what we call the public charge doctrine for all persons applying for green cards. Now, USCIS announced this reinterpretation last fall. It was set to be implemented on October 15, 2019. However, because of several lawsuits, the implementation was delayed, and there was an injunction from the federal courts that blocked USCIS from putting this new policy in place. However, as of February 24th, 2020, the injunction was lifted by the federal court, and USCIS was allowed to move forward with their new interpretation of the public charge rule. So what does this mean for people who are in the process or will be filing for green cards? Well, the good news is if your case was filed before the implementation of the rule on February 24th of 2020, this new interpretation will not apply to your case. However, it is important to note that the public charge rule has always existed. Like I said, this is just a reinterpretation of the prior rule, which comes from a statute that has existed for, I believe it's part of the original 1952 Immigration and Nationality Act. USCIS has just now reinterpreted how they will apply that standard. This reinterpretation is also followed to the U.S. consulates abroad, and the Department of State has come up with its own new procedures on evaluating the public charge rule as well. And I'm going to talk about that briefly later in our video. Now the good news is, as I mentioned, on February 24th, the rule became implemented because an injunction was lifted, but this doesn't mean that this fight is over yet. What that means is that the courts decided that USCIS could implement the rule while the case remains in litigation. Previously, the injunction had prevented USCIS from putting the rule into effect while the court case was pending on the validity of the rule itself. And the reason I want to mention that is that there is a chance that this new interpretation of the public charge rule will eventually be thrown out by a court. However, right now, as it stands, we are required to file most green card cases under this new standard. So let's talk first about which types of green card cases this new rule applies to. It will apply to 90% of green card filings. It applies to all family-based green card applications, which are the majority of our green card applications. It also is going to apply to all employment-based green card applications, as well as investor green card applications. So that is the majority of our green card applications generally. We have a few smaller sub-classifications which the new rule will not apply to because the old rule didn't apply to it as well. These people are exempted from the public charge ground of admissibility. That is people who are getting their green cards under a special provision of law called VAWA, the Violence Against Women's Act, although it applies equally to men as well. Those are people who have been victims of domestic violence at the hands of a U.S. citizen or resident that they're married to. Special immigrant juveniles, those are people under 18 who have been subject to abuse, abandonment, or neglect by their parents and have become wards of the state, so we obviously are not applying these rules to them. They do not apply to people who are getting their green cards because they were previously granted asylum or refugee status. It's not going to apply to people who are getting green cards because they previously won a U visa as a victim of crime in the United States. It does not apply, and this is important for us here in South Florida, to Cuban adjustment cases, whether it is the Cuban national or the spouse or child of the Cuban national. So there are, like I said, some sub-classifications that this new rule will not apply to, but the vast majority of green card applications, this new rule will apply to it. So what is, Sasha, you keep talking about this public charge rule. What is this thing you're talking about? So, to put it pretty simply, the public charge is a ground of inadmissibility. That's a fancy word we use for a base for denial, ineligibility to obtaining a green card. It's a ground of inadmissibility that looks at whether the applicant is likely to use federal government benefits in the near future. And the standard is more likely than not. Now, previously, we had used the system of what we call the financial affidavit of support, the form I-864, which is filed by every, in a family-based case, every person petitioning for their loved one. That was the basis or the starting point, and really the ending point mostly, for the public charge inquiry. If your petitioning sponsor met income threshold requirements, and I'm going to talk about those thresholds in a second, then they assumed that you were not a public charge. If your petitioning sponsor did not meet the income requirements, then you could have a secondary sponsor, often called a joint sponsor, who shared their tax information and their employment information and served as a secondarily liable sponsor to the case. And the purpose of that sponsorship, there's actually a contract signed between the sponsor and the U.S. government, which says, I'm promising to support this person, and I am promising that they will not use any federal public benefits. And what are these public benefits you're talking about? So they're really, it's not all benefits, but it does apply to the major public benefits that we think of, being food stamps, or SNAP, if you want to call it by its proper name, general welfare programs, Medicaid, programs such as that, Section 8 housing, the low-income public benefit programs that we have in the United States as safety nets for everyone. When I petition for somebody in their green card, I have always had to sign a sponsorship which promises that when the person gets their green card, they're not going to go and apply for food stamps and welfare and all of these things because I have promised to support them. Now, that is still in effect. We still have to file the I-864 financial affidavit with each and every case. However, now we have to file an additional 18-page application form that's very, very complicated and burdensome called the Form I-944, Declaration of Self-Sufficiency. And what that means is that they're no longer just going to look at the financial sponsorships the way they had in the past. The financial sponsorship continues to be a factor in the public charge test, but is only one factor of many, many factors that they will now look at. If the petitioning sponsor earns above the income threshold, that's going to be looked at as a positive factor. If the petitioning sponsor earns more than double the minimum income threshold, that is going to be, quote, an extra heavily weighted positive factor. So it's obviously very good when the petitioning sponsor has a higher income and is well over the income threshold. So what are those income thresholds? For a family of two, it is about $22,000 a year per your total income on your U.S. tax return. This is 125% of the poverty level. Now, of course, if you want to be double that, you would obviously multiply by 2 and come up with about $44,000 for a family of 2, and that would be considered an extra heavily weighted positive factor. So for example, if I'm filing for my husband or wife, if I make $45,000 a year, then I'm going to have that as a heavily weighted positive factor in my inquiry. Now, can you still use a joint sponsor under this new test? You can. You still have to meet all the requirements for the I-864, so if the petitioning sponsor does not meet the income thresholds, then you are required to file a joint sponsor or use assets to supplement income. But the use of a joint sponsor will be a negative factor because the petitioning sponsor does not meet the income thresholds. So although you can use a joint sponsor, you have to know that that will be a negative factor in this new test. So, like I said, the test has shifted from just looking at the financial sponsorships to what they're calling a totality of circumstances approach. Now, totality of circumstances in general is not a bad legal standard, But in a case like this, where they have reinterpreted this long-standing rule and provided very general guidance on how they will weigh these factors, and really there's about 46 factors that they're going to use to weigh, and they stem around major factors such as age, health, financial status, education and skills, health insurance, and then there's all these variations of those major factors. They will now look at all of them and weigh them. And I had mentioned before something about a positive factor versus a heavily weighted positive factor. They basically have 5 categories of weight on these different factors. And it goes from heavily weighted positive, positive, neutral, negative, heavily weighted negative. And so, the problem for immigration attorneys like myself, there's only 70-something board-certified immigration attorneys in the whole state of Florida, and we go through a very, very comprehensive testing and vetting process to become board-certified as experts in immigration law. And people come to me as an expert about, will their case get approved under this new standard? And the truth of the matter is, I cannot give them a clear-cut answer anymore, because I don't know how any given officer, because this will be a subjective standard that one particular officer will go and weigh all of these different factors. I can't give them a clear-cut answer of how they will weigh each of these factors. I go through them, I tell the people you have these positive factors versus these negative factors, but ultimately I'm not making the final decision, so I cannot tell them, do your positive factors outweigh your negative factors? And so, because of this, it's going to create a lot of non-uniformity in the application of our immigration laws. You may have someone with the exact same fact pattern appear in front of one immigration officer in one immigration office and get an approval of their green card case, and have someone else with almost the exact same identical facts get denied in another immigration office. And it leaves a lot of officer discretion on how to weigh the factors and make these ultimate decisions. We just recently, for the first time in my 10 plus years of being an immigration lawyer, got a denial on the public charge doctrine under the old rule. And my client is a 30-year-old Canadian woman, healthy, able-bodied. The officer, it is clear from the decision, did not like her and decided to deny on this public charge doctrine. And, we are going to appeal it and everything, but it does really just seem from that decision that the officer just decided they did not want to approve her case and found a way to fit her into these negative criteria to be able to deny her. And of course, this is an English-speaking Canadian woman who has a university degree from the University of Toronto, but for example, they made mention in the denial letter that yes, you have a university degree, but it happened to be in psychology, and she had never worked in the field of psychology after graduating. So they basically said, your degree is useless. Now, that is completely a matter of interpretation. You don't have to be a psychologist to use a psychology degree. I feel like I should have gotten a psychology degree because I do so much counseling as part of my work. And there's so many different ways that a psychology degree can be useful and so many other types of work. So to say just because you didn't pursue a career in psychology as a therapist or a psychologist doesn't mean that that degree is useless. And of course, again, that's a matter of interpretation for the officer. Speaking English is a factor on this new test. So, one of the examples I've been giving is that, I can, have an engineering degree and be a biochemical engineer in my home country, but maybe I don't speak any English. Maybe I come from a country where my language is not that familiar. I'm just going to choose a random country. I'm Turkish, from Turkey, and I only speak Turkish. But I have this high-level master's degree in biochemical engineering. The reality is I may not be that employable in the United States despite this high level of education because of an English barrier versus somebody who may have a certificate as a hairstylist and speaks basic English, they may be more employable in the United States, even though, generally we would say a master's in engineering is more valuable than a hairstyling certificate. In this case, I would argue the hairstylist actually has better employability in the United States, and a better job prospects. So, who makes that determination? One single officer looking at your case. And this is one of the reasons why this reinterpretation of totality of circumstances is so scary for applicants and attorneys alike. We will just have to see. Right now, because cases were only filed under the new rule as of February 24th, this video is being recorded just for reference on March 24th of 2020, 1 month later, and in midst of the global corona COVID-19 viral epidemic. So hopefully you're watching this video in the future and everything turned out okay with coronavirus. But we just don't know how this rule is going to play out in effect, because people are not getting interviewed on their green card yet who filed their cases after February 24th of 2020. It's going to take a few months, especially now with USCIS being closed to interviews, and there's going to be a backlog on interviews because of coronavirus, that we need to see how it plays out once people go to actual interviews. So right now, this guidance is very preliminary in the fact that we just don't understand exactly how this rule will actually be applied in the future. So what does this new I-944 form ask for? It asks for everything under the sun, in my humble opinion. I feel like I am not only an immigration lawyer, but also essentially a mortgage broker at this point. The I-944 form, which is for the applicant, the person obtaining the green card, asks for you to list all of your university degrees, if you have them, all of your certificates, whether it's being an air conditioning repair person, to a hairstylist, to a travel agent, whatever certificates the person has. It requires a U.S. credit report, which is very problematic for a lot of people who obviously don't have U.S. Social Security numbers. Those people usually fall into two camps. One being people who have been living in the United States without status for a long time, and those who just arrived. For example, I just arrived on a fiancé visa or tourist visa, and now I'm getting married to my U.S. citizen boyfriend or girlfriend. I don't have any credit history in the U.S. I never lived here before. But the instructions to that application require that if you do not have a U.S. credit score and a U.S. credit report, that you provide evidence that you don't have that, which, it's always difficult to prove a negative, and that you supplement with secondary evidence that you have been paying your bills on time. So how do they expect people to do this? Anyone can guess. I've been advising clients that if they have credit scores from their home countries, to be able to submit those, or submit some evidence that they were even paying simple bills like a cell phone on time in their home country. But again, this is overly burdensome for people to gather this type of evidence just to be able to file a green card application. So like I said, we're adding things like credit reports, adding university degrees. If your degree is from a foreign country, you must get it evaluated by an evaluation company and submit the evaluation. We have to submit proof of health insurance. This is a huge one that is killing people. I guess the lack of health insurance is what really is killing people, but the reality is that health insurance in the United States is extremely expensive when it's paid for out of pocket. Even sometimes adding your spouse to an employer-sponsor plan, the monthly premiums can be extremely high. If you do not have health insurance, it is going to be a negative factor to this test. Having private, unsubsidized health insurance is a heavily weighted positive factor. Having private, subsidized health insurance is a positive factor. That means, I can get my insurance through the Affordable Care Act, Obamacare marketplace with a subsidy, and it will still be weighted as positive. With no subsidy, it's weighted higher, but it's still a positive factor to have subsidized private health insurance. However, if you read through the rules of the Affordable Care Act marketplace to purchase insurance through the marketplace, it does require that your green card case already be pending. So it's kind of a catch-22 chicken and egg situation. You need to have that green card receipt in order to be able to get healthcare under the marketplace. And with the green card application itself, we need to send proof of health insurance. So I'm recommending to my clients that they get travelers medical health insurance initially, and then once they get their green card application receipts, they go into the marketplace. It is a qualifying event to be able to enroll outside of open enrollment, so that is possible as soon as you get your green card receipt to be able to go into the marketplace and apply for health care, so that by the time they have their interview and are getting their final decision on their green cards, they will already have their private marketplace insurance in place. Obviously, the ideal situation would be to be added to a spouse or the petitioning family member's health insurance policy, if that's possible. If that's not possible, the next best would be some private health insurance. Applying without health insurance requires you to demonstrate how you would pay any anticipated medical costs. So it's not that you can just say, no, I don't have health insurance. If you say, no, I don't have health insurance, you are required to provide an explanation of how you would pay your medical bills. So, this is extremely scary for a lot of people. This will be used against a lot of elderly people, especially. We've already seen the consulates abroad begin to deny cases for parents of U.S. citizens. So, unlike what the news tells you, there's no such thing as an anchor baby. In order to be able to apply for your parent as a U.S. citizen, you must already be 21 years old. So I guess in theory, you could come over the border, have a baby, wait for that baby to turn 21 years old to then file for your green card. But people under 21 years old cannot file green card petitions for their parents. So normally the parent is older in the situation of sponsoring a parent. And we have already seen that when the parents are elderly, because they do not qualify for Medicare, even if they're over 65, you just cannot get Medicare if you haven't been living here and paying into the system, and you need to be a U.S. citizen, they have to pay for private health insurance. And even under the Affordable Care Act marketplace, because of their age, those premiums are often over $1,000 a month for people, in their 60s, 70s, 80s. And so we've already seen that they've been denying cases, saying that we just don't think your parent is going to be able to pay for their medical costs. And of course, just naturally, older individuals have more medical needs than younger ones. And so they assume, that you have to pay for your parents' medical care. And if they do not believe that the sponsor has sufficient funds to be able to pay for medical care, they are denying those cases already. Age itself is a factor in the test, and being over 60 years old is a negative factor in and of itself, even with private health insurance. So again, some of this does appear just to be a way to narrow cases for example, parents of U.S. citizens. Interestingly, being under 18 is also considered a negative factor, which I think is ludicrous personally, because obviously children can't work or support themselves, so how are you going to hold their age against them? But they are holding age against young age against people because they do not work. And I guess statistically, children are benefits often of benefits like food stamps, Medicaid, things like that. So they just, are looking at the population groups that are most likely to use public benefits in the first place. If you speak English, you have to show proof that you have English skills, and that proof is a certificates in English, college or high school courses in English, and unbelievably, I swear to God, this is real, guys, there is a requirement that if you are a native English speaker, so for example, if I come from Canada, I come from the UK, I have to prove my native English skills. And that can be done simply by submitting like my high school transcript that shows that I took English class in high school. But you actually have to prove when you come from a country that is filled with native English speakers that you are a native English speaker. So This is what I was saying about this new application form being completely burdensome on applicants and attorneys because we have to submit so much information and evidence that we never had to submit before. Another part of the I-944, and this affects both sides of the spectrum, is a list of assets and liabilities. So assets are total household assets. So for example, if I'm marrying a U.S. citizen, I must include my spouse's, all of their assets. Liabilities are only the applicant, but assets are the household. And so on one side of the spectrum, I often represent people who are applying for investor green cards. They've invested under the old standard $500,000. The new standard is at $900,000 now. And these people have assets all around the world. And now they're required to list every asset that they own on these application forms. And so for some people, it's a good problem to have, obviously having tremendous amounts of assets and having to list them all, but you have to go through and figure out the value of every asset that you own worldwide and declare it on this application form. On the other side, people who lack assets, that's going to be a negative factor for them, and people that have high debts and liabilities, and debts include student loan debt, credit card debt, in addition to our standard debt that we think about, like mortgage loans and car loans, things like that. All of those are going to be weighed against the person. So it's incredible what they are looking at now in issuing a green card. It just creates a tremendous amount of uncertainty for applicants because you can think you have most factors going for you, and then they could focus in on a negative factor and say that the positive does not outweigh the negative. It's very, very nerve-wracking now to go through this process, and they've made it basically impossible to do without the guidance of a lawyer, which of course goes back to the irony of the whole thing, which is that the people that are going to be most affected negatively by this new rule are lower income applicants, and they are the people least likely to be able to afford a qualified immigration attorney. And so we are just going to see a ton of people boxed out of the system by lack of resources to be able to actually hire lawyers to help them through this process. Like I said, all of these things I'm speaking to you about are required initial evidence to file a green card case. It also means it's going to take us a long time to put together green card packages. I estimate it's going to be a minimum of 30 days from when we consult and we get hired for a case to have these packages ready, because people are going to have to request transcripts from their university, get those transcripts translated if they're in a foreign language, send those translated transcripts to an evaluation company to have an evaluation of their degree. USCIS is now only accepting tax transcripts. You have to request your tax transcripts as the citizen sponsor. That can be done online relatively quickly, but for example, if I just filed my 2019 taxes, it may take a few weeks before that's reflected in the system, and that I can order a tax transcript of that new tax return. Obviously, getting health insurance in place will take a little bit of time. There's all of these different factors that will just make it take so much longer to even put together your application package. And there are some new rules from last year and the year before, which give USCIS a lot more power to deny cases without even interviewing them when they're missing this required initial evidence. So you really have to go in the mindset that everything must be included, that you can't be missing any of these documents, or they could just send you a denial letter saying that you failed to provide required initial evidence per the USCIS instructions. I know, it's a lot, and it's a lot for us too. And of course, this is required across the board. 99% of immigration lawyers have had to raise their fees to reflect these additional hours of work that need to go into the case. I've had people where we pulled their credit reports and they had so many delinquent credit accounts that we recommended they did not file a green card at all under this administration. We thought it would be a waste of money paying us and a waste of the government filing fee for a green card, which is alone $1,225 to even apply, because so many delinquent accounts were going to be viewed so negatively against these people that it wasn't even worth applying. We are helping people to apply for credit reports through the mail that don't have social security numbers. I mean, it's just so many things that we never contemplated doing as an immigration law practice that will now be required to just do simple immigration cases, like spouses of U.S. citizens. And, you know, as someone who has sponsored their spouse for a green card, my husband is a native of Johannesburg, South Africa. I look at this and, you know, I'm like, this is just so overwhelming. I put myself in the shoes of my clients, and it is just, I've had people say, like, I don't even want to do it. I mean, most people have to do it, but, you know, they look at the requirements and they're just like, this is too much. I don't even know where to start. And, you know, I tell them we're going to go through it one by one and just go through our list one by one. And, you know, it's a lot, and I call it the homework, or I speak fluent Spanish, and to my Spanish clients I tell them this is la tarea, and I give them all of their homework to do, but it requires so much work for both the attorney and the applicant that was never needed before. So like I said earlier, cross your fingers, pray if you are that type of person, that we do have a federal court eventually overturn this rule. I think it will be overturned, if it is overturned at all, on the fact that it's going to cause there's going to be no way to predict the outcome of the cases properly, and the law is supposed to provide predictability, so that you can come to a lawyer like me, and I can tell you, I don't see a red flag in your case. I think everything should go through fine, and be able to give you that reassurance, whereas right now, we can't really give those reassurances because we just don't know how these factors will get applied to each individual case. So anyways, I hope this video has helped to provide a little bit more guidance regarding this public charge rule. Like I said, we have this parallel process happening at the U.S. consulates abroad, but they don't use the form I-944, and they don't require all those supporting documents like degree evaluations, credit reports, things like that. So the process through the consulate, although the standard is the same and they will weigh those factors, they require a very easy form called the DS-5540, and they don't require any of the documents that the I-944 form requires for people processing inside the United States. So although there is a risk of denial that is much higher now for public charge outside of the United States, at least on the documentary requirements, the process itself is not quite or even remotely as burdensome as it is to do a green card application inside of the United States. If you guys have any questions, you know, please feel free to reach out to our law office. Our phone number is 786-442-3177. Our website is www.rwlawgroup.com, and we really recommend people going onto our website where you can schedule appointments using our online calendar system and get a consult, and we can go through the factors and how they apply to you, and everything that is required to be able to file a green card application. Anyways, we hope you enjoyed and that you learned something, and as this process continues to unfold, I'll be continuing to do these informal videos regarding how we are seeing the application of the rule play out, as I think it's only time will tell how deep the impact of these new rules will really go on applicants. Anyways, we hope you take care of yourself, and thank you so much for tuning in. Have a great one.